Today is January 16th, 2014. I'm Aloysius Hogan. I'm with the Competitive Enterprise Institute. This is the third in our series of Free Market Center for Economic Freedom live interviews broadcast on YouTube. Today we're very pleased to have Cyndi Cunningham. Cyndi Cunningham is in Minnesota. She's one of the care workers, a key care worker who has great experience with unionization efforts and is going to tell us her experience. And so, Cyndi, welcome. Why don't you tell us a little bit about yourself?
All right. Thank you very much for the opportunity to speak on the topic. I do live in St. Paul, Minnesota, and I'm a family child care provider. There are two different aspects of this unionization. One is for home health providers, PCAs, and the other is for family child care providers. So I've been having my own small business child care provider in my home for about 15, 16 years.
Problems began regarding unionization for you how many years ago?
I first became fully aware of it in 2011, about January of 2011. I was at a conference and listened to some other providers talking about a union and door knocking. And to me, it's one of those things where I had to hear it about 3 or 4 times to realize what they were really talking about. In retrospect, about 2010 or 8, even back as far as 8, I could remember having some people come knock at my door and ask if I was interested in joining a union. I said no, and they went away, and I never heard anything more about it. And then in 2011, our state association was putting on a conference that was having a panel, and I became aware just by word of mouth being connected with other providers, and was referred to and hooked up with a group of providers who we have a coalition that essentially has been working since 2005. So I've been working with these other providers since 2011, trying to educate other providers and the public.
The state association, what is the name of the state association?
The acronym is MLFCCI, Minnesota Licensed Family Child Care Association. The coalition is totally separate from anything. We're just a total loose entity of our own, and just providers who have gotten together to educate people. The state association heard many complaints and comments and questions from providers across the state. And they had a conference coming up in May of 2011, and so put together a panel of providers and people on the unions to try to explain, just give us the opportunity to know and understand of it. That was the first time, May of 2011, that I truly sat down and met with lots of people and just trying to get the facts on this. There were 2 people on the panel, Heather Falk, who was one of the very original in 2005 providers who found out about it, was approached by it, didn't like it, and worked through the state to try to educate providers in 2005. Jennifer Parrish was the other provider who again had done a lot of the original work and contact and trying to figure out what this unionization was about and how it would affect us. Heather is in Minnesota, up by Duluth.
Okay, and Jennifer is in...
She's in Minnesota. She is in Rochester. Right before the conference for the state, one of my very first steps was I ended up at I'm in Ramsey County in Minnesota, and I did a lot of research just listening and talking to other providers, trying to find as much information as possible. And one of the steps was I went to a county association. I think the appalling part for me was there was a provider at the table who had had signed a card, had been told that it was for information, and also at the table a provider who is now the president of the charter union was there, And the president, Lisa Thompson, was trying to convince the other provider that this was just for information, that it was not a union card to sign up for the union. And if I wouldn't have been, I felt that if I wouldn't have been at the table, it would have been left at that. Because I was able to re-question and put out, kind of challenge this view, this provider did find out that she had actually signed a union card for membership. And she was quite upset because that's not at all what she had been being told, including right there at the table.
So the union was misleading her?
Yes.
Okay. Explain their claim for, or their rationale for being able to unionize you.
Well, the rationale was confirmed by the legislature last spring in June of 2013, when it was finally passed by the Senate and the House and signed by the governor, that this legislative language that we were eligible to be looked upon as being as employees of the state for the exclusive representation only for bargaining rights. So the connection is if you have a family who is using child care subsidy, which is the government-funded child care subsidy program, you therefore are technically considered an employee of the state for purposes of bargaining about child care subsidy and all licensing issues.
So under that theory, that everyone who receives a subsidy, or at least a child care subsidy, is able to be unionized, if that were the case, then in theory, by extension, everyone who received a subsidy should be eligible to be unionized. If that logic were to hold across the board, and the government gives lots of subsidies to lots of people, the concept would be ultimately all those people could be unionized in various different unions.
You know, that's a question that we have put out, and we don't have any information where the unions, excuse me, are actually trying to take the next step of what you just described. In our case, our biggest argument is the child care subsidy is actually the family's benefit, not ours. And so we do not get, it comes from the government to us, but it's technically the families. And in legislation this last spring, it was proven in stated in legislation that that was true. But the powers that be that voted it through ignored that and kind of made it ours. So the family technically is the one who gets the subsidy. We provide the care, and that money follows the family. And so if the family leaves my care and goes somewhere else, those dollars go with that family. They do not stay with me in any fashion. We have raised the question, I personally, you know, if it's us, if it's child care subsidy, is it not Medicaid, Medicare, food stamps? You know, do grocery stores start coming under this next? There is the point where if the government can be put under this unionization, if welfare subsidies can be put under this, cannot not be everywhere. At this point, it takes legislative action to make those leaps, and it's not been happening yet at this point in time.
Now, are there any members currently unionized, and if so, are you one of them?
No, what the legislation did in 2013 is changed our status to as employees for bargaining and technically gave the right for the union to organize and to allow a vote. What ended up happening after that is the coalition and other providers that I'm associated with, National Right to Work, and we are involved in a federal lawsuit. It's Parrish versus Dayton, and under that lawsuit, we were defeated, and then there was an appeal. And at this point in time, the vote process, the actual organizing efforts, are technically on hold, and we've been conjoined with a lawsuit, Harris versus Quinn, in Illinois. That suit itself is being heard before the Supreme Court next Tuesday, is oral arguments. Until that Supreme Court decision is made, the public and formal organizing efforts are on hold. We do know the union is going door knocking and is still reaching out and publicizing to providers for unionizing. November of 2012, I believe there was a charter union that was formed and was signed. So there is a charter, there's a president, vice president, and all leadership is in place for this union. Right now it's a by choice. We've been told anywhere between 50 and 100 providers in the state have chosen to sign up to be in the union, but we don't have any documentation, nor have they provided any.
So those 50 to 100 by chosen to be in the union, it's your understanding that only those 50 to 100 are actually paying dues or already paying dues? Is that your understanding?
They have a choice to pay dues or not at this point. There's no mandatory union dues because there is not a, I don't know if it's correct terminology, there has not been a union vote where the union is recognized and sanctioned, I believe is terminology. So there is no forced process or with that at this point.
So the first lawsuit was a federal lawsuit in the federal district court, and that was the one that was initially lost and appealed to the Federal Court of Appeals. Is that correct?
I believe so. That's slightly out of my... I'm on the lawsuit. We're involved in it. Harris versus Quinn is the primary piece that's being heard. And then there's a number of amicus briefs, including ours, that is included in that. And so since we've been conjoined with that, the Supreme Court, I believe, has until June to make a decision on Harris versus Quinn that will then impact whether or not the vote can go forward here, whether it's considered constitutional, because our claim is that it's unconstitutional to be forced into this kind of unionization process.
What's your argument? What part of the Constitution are you arguing is being violated?
The freedom of association, that we can choose to who we want to do business with. On a layperson, I speak better off of the layperson's part of it. I'm a small business owner, and to have legislators and a union decide that we even need to be in this position and change the work status, change my employment status to be an employee of the state, is where I, as a layperson, say that that is what is wrong. We shouldn't have to do that. Minnesota is a fair share state, so it's not a right to work state, so therefore we would need to have to pay fair share dues if we conduct business with these clients at all. So I would be forced to be in the position of taking clients that are on child care subsidy and then having to either join the union and pay full dues or pay fair share dues, or else choose to not conduct business with the clients at all.
It's kind of Orwellian terminology, fair share, when you're saying there's nothing fair about it at all and I shouldn't have to pay any of this, and it's outrageous that I conceivably could have to pay it when I don't want it, and they're calling that a fair share.
And that's the common terminology. Anytime that there is a union and you seemingly benefit from it, or it's deemed that you benefit, you have to pay your fair share with it. The part that the money isn't huge, the part that's really huge to me is the exclusive representation, that child care subsidy clients are not a specific niche. I can't determine when they come in and out of my business or when someone's going to choose to call me. I have absolutely no control or whatever impact on whether those clients come to my door or not. And the exclusive representation, though, is for all aspects of licensing and my business. So I would have no voice in what the union would decide to do or not do, and yet they would be exclusively representing. They can't cookie cut out legislation or rulings or licensing that only pertains to CCAP, to the child care subsidy program. Anything they would do other than rates for child care subsidy or procedure directly for child care subsidy any of the other things they would bargain on would dynamically affect my licensing in my business. So they're trying to cookie cut out a group of people to unionize, and yet what they will be deciding would affect all of us.
That's a good point, that the exclusive representation actually means quite a bit to you. Have you heard any estimates about the monetary encumbrance for how much you'd have to pay to them? Have you heard any estimates at all about how much you'd have to pay per year?
We've, across the United States, the rates have been around 25. We've heard up to 75. There's a variety. They come in low, they stay low for quite a while in the other states. And right now, I believe it's at 25 a month, which again, you know, it's like, that's not a whole lot of money. In some ways, it's more than what I want to pay. But again, that's where the real big piece to me is, one, with that, I would have no control over where those rates would go. They can raise them and do whatever they want, because those that are then full paying union members would be the ones to decide what the fair share due was and who and how it got paid. And again, then I would be subject to what their decisions were, and I would have no voice in what the decisions are. Again, that's where the exclusive representation and decision making would be totally out of my hands. Dayton is Governor Dayton in the state of Minnesota, and the Harris versus Quinn is the governor. Quinn is the governor of Illinois.
How many people have joined with you and Ms. Parrish?
I think we have 10 at least on our lawsuit. It's titled with the Parrish versus Dayton, and I haven't looked recently on who is all on our list, but it's at least 8 to 12 other providers that are on our particular lawsuit against Governor Dayton.
You are trying to get some publicity for this this problem that you're facing, and what other forms of outreach? You were trying to reach out to us and send an email, so I appreciate that here at the Competitive Enterprise Institute. But to whom else have you outreached?
We have worked hard to try to reach all providers. We've worked with reaching out to the public. In Ramsey County, we have a unique situation where the Ramsey County commissioners themselves, under budget for 8 years, have budgeted money for providers who are in the union. And since I found out about this in 2011, I have been empowering providers and the public to push back against this. This is not a proper use of taxpayer money in Ramsey County. And as of last week, or week before, within the last couple of weeks, we're finally getting some direction and some pressure where we might be able to get that changed. To me, that's again how the union and politicians seem to be working, with a whole lot of not information to lies, and how money is being used and where authority or decision-making and power gets put.
What other things have you been told that didn't seem quite right to you?
I think I was quoted last week ago about nothing seems right. They have everything from, you know, what might be construed as a reasonable thing, which would be increasing child care subsidy rates, but those rates are actually the parents' rates, not ours, because I charge what I choose as a business. So what the child care subsidy program pays isn't my income. I charge additionally usually because of my rates. There's everything from they can intervene with licensing if we have a licensing violation. They promote that they can intervene and go to licensing and act on our behalf. Legally, they cannot. Because that's a whole, then we're into a legal problem, not a internal employer-employee situation. They have worked and said that they can offer medical insurance or other kinds of benefits in that way. In general, across the United States, that has not happened more than 1 or 2 times. I believe it's in Washington when they did have a medical insurance offered. It was a very small number of providers who actually qualified for it. and then there was very few who could actually obtain it because of the amount of money that was actually allocated for it. And like in a case, if I think it was that you had to have 3 families who used child care subsidy before you could actually even be on the insurance. And if you lost one family, you would then therefore not qualify for the insurance. Child care subsidy, the last statistics I've seen, about 1/3 of the providers in the state of Minnesota actually have children in families who use the child care subsidy. So you're looking at a small number of providers who could ever even participate in this. I think where they have made grounds, not under the right pretense, where they actually band together and so your voice can be heard. It's to me the union become the union jargon. Have your voice, we're your voice, and somehow they present that they're going to be able to go to legislators, go to DHS, and act on our behalf. None of that's proven true.
Right. Actually, at this point, you consider probably the association to speak more on your behalf and to bring you together and to make sure that your voice is heard more so than the union. You have preferred to join of your own choice the association.
Yes, I belong to both my state association and my county association. Dues are $35, $40 for a year. The difference is I have freedom of association. I can go in, but if the association is not backing or sustaining or doing things that I want, I have the individual right to go and act on my own behalf, both with legislators and with DHS. And I have done that in many ways. I was a primary testifier last spring when there was a lot of legislation going through. I worked with our state and county association and our coalition. And we did a lot to protect providers in legislation. We were not successful on the union part, but as far as actual legislation on safe sleep and some other things that were being put forth, again, that were going to be harmful to our businesses, we were very effective in getting action against that. The union chose to not participate in those legislative actions at all. But I can come and go and I can do it. If the union goes through, those voices may technically be still available to us, but an exclusive representation from the union takes a whole different weight away, and it's yet to be seen what happens.
Let's paint a little picture of this. The 10 or so of you who are parties to Parish v. Dayton, would you just say that most of these are women, and what percentage are mothers?
I've not ever seen the statistics about how many providers are males, but the highest percentage are females, parents with children. I would say would be the highest percentage of it. It is a primarily female-dominated industry. One of my little caveats that I got involved with was that the union promotes a document put out by the National Women's Law Center in DC, and that's what they use to say this is how wonderful and good the union has been and what they've done. When I first became aware of this, and I read the document. In the document is where I found out about the money being given to providers here in Ramsey County. It was I believe they said up to $100,000 that had been given to the union. And at that point in time, I knew I had never heard of that at all. I ended up calling the National Women's Law Center and talking to the primary author in the paper. And what I did not understand is why a union and government officials should have such an impact on a strongly female-dominated industry. And as females, we don't want to give that up. As business owners, we don't want to give that piece up. We hold on to it dearly.
Are there any other significant meetings or documents or points in the timeline that stand out to you?
Well, it's probably many. I think one of the ones that I've gone back to is the first Heather Falcon and I believe one or two others were involved with it. When we had a Republican leadership and Governor Plight was in office, she was able to get a copy of a letter signed by him that he would not at that point in time do an executive order to unionize. And then when Governor Dayton came through and was elected and the DFL rose to power in Minnesota, that's when the actions really took place again, and the push started coming back again. And in 2012 is when Governor Dayton did sign an executive order to unionize. We were able, as providers, there was another lawsuit by another group that stopped that unionizing efforts. And the ruling at that point in time was that a governor could not, the governor's executive order was deemed unconstitutional, and that the legislatures needed to be the ones making the decisions. So therefore, then in 2013, that's what was pushed through.
Was it you who made contact with the National Right to Work, or did the National Right to Work contact the association, or how did that connection get made, you know?
It was through Jennifer Parrish and the National Right to Work. I was not personally involved in that direct connection.
The experiences you've had are pretty much shared by Jennifer and others in the other counties that you mentioned, the Rochester area, the Minneapolis area, is that right?
Yes, virtually across the state, we continue to hear story after story about people being told to sign cards, people being misled or not given information. I just heard of a county commissioner saying, "Oh, but you won't have to join the union," and that is true. But they leave out the pieces. You know, that sounds good, but they leave out the piece that you would have to pay fair share dues and still be impacted. So there's always that piece that they may not lie and totally mislead, but they will always make it sound like it's not going to be a problem for us. Our industry is one where I'm in my home right now by myself with children. Some people use the word of isolating. It is in some ways, because we don't have that day-to-day public coworker discussion in person that goes on. But yeah, I would say the majority of providers experience the same thing, or they've been told and really, maybe need somebody to stand on their behalf and don't know who else to turn to. And so therefore then the union sounds like a good option.
So when the two people, you said it was two, I believe, who knocked on your door,
yeah,
and made the pitch to you, how did you feel did you feel pressured by them?
At that point in time, I met them at my front door, and people who know me, they gave their one sentence pitch, and I said, "No, thank you," and turned around and shut the door. There are many stories of where when providers were serving lunch or doing other things or in their homes with their children or their backyards, the union organizers would literally just walk in the house. And we're in a business where we have licensors come in, we have fire inspectors, we have many people who come to our homes. We also don't know who our next person is that might end up being a client. And so there's that point of putting up a guard quickly. I do. Not all providers do. And rightly so, none of us are used to this. Also, a part of what the door knocking is, the vast majority of people who are door knocking are not child care providers. They are people who may are often members of unions within their own industry and within their own right, and they have that experience. So they come and don't have a clue what our business is about, but speak from their experience in a union.
There are a lot of major unions throughout the United States: SEIU, Carpenters, LIUNA, AFL-CIO. Are you familiar with any particular union that's been making this push?
This specific push started out early on with both SEIU and AFSCME. Are the two that started. They split the state, and then I believe it was in 2012, AFSCME took over the full state. And so in-home family child care providers, AFSCME is the unionizing entity. SEIU is attempting to organize the PCAs, the personal care attendants, under the health care. And as a caveat, one of the things that we're greatly against in this is they are lumping unlicensed family, friends, and neighbors, terminology FFN, FFNs, family, friends, and neighbors. So these are people, a family member, a friend, or again, a neighbor who a person, a family is paying through child care assistance program, and they legally have the right and the ability to do that. But they're putting that group of people, those group of providers who are very important, very critical, provide a great service, in with us as licensed providers. So if they were to become unionized and then start negotiating and representing, they would be representing both of us at the same time. That would enable the family, friends, and neighbors to be able to impact our licensing options. To me, I put it in the same, I've been told it doesn't work, but I think it does. I'm a teacher by training. It's like putting teachers and paras or paraprofessionals in the same union. That doesn't happen anywhere. They're kept separate because of the overlap of where, you know, what the work environment situations are. You don't overlap those two types of worker employees.
With your experience now with Governor Pawlenty and Governor Dayton, has this unionization issue and pressure additional headache for you that you don't need because you've already got your business, you've got your family, you've got your ideally relaxation time as well? Has it gotten you more interested in politics and the gubernatorial elections in the future, or legislative elections, local elections?
I would say that I've probably stayed pretty much the same. However, what this has really enabled us to do is to empower other people to get involved. I'm involved in my block club and in my county. I think it's really put me in the position to speak out more to other people, to say this is why you need to be involved. This is why other people need to be. So I feel like there's a whole group of providers and the public that are paying attention that didn't pay attention before. I would say I can speak more specifically in elections, using this as an example of where people need to pay attention. And I probably am a bit more active than I was before.
So this whole experience has gotten you more active than you were before and heightened your awareness of when people make approaches to you and when people are making false statements, or at least misleading statements, if not false. Are there any other final conclusions or bits of advice that you would give us after all this?
I think people need to pay attention to really what's going on in your government and in organizations such as the union at this point. I've never been a person to be against unions. In this case, this kind of unionization should not be allowed, and to watch legislators be able to literally push it through. I was at the Capitol throughout the whole process, and it was very sad to watch my own legislator knowingly go against what constituents wanted in the state of Minnesota. Everybody was vocal against it. But the legislators went ahead and put it through.
Why do you think your legislator did that in spite of hearing from people?
My legislator, my House representative, is actually an AFSCME union member.
So it was the union connection of the legislator to herself, right?
My senator actually finally listened to me, and we had a good discussion. And his view was strictly that that potentially this unionization would help the child care subsidy program and raise the rates so that families would benefit. I actually have a little bit more respect for him, even though I disagree with that's the best use of my business money. And that's what I told him, is I don't think my business should be doing that. But I did feel that at least he knew what he was voting about. He wasn't trying to cloak it or lie to me or whatever. He knew exactly what this was going to do. And that was his highest priority, was to help families on child care subsidy, not protect my business.
So if that were to be become true, there would be more spent on that, which would be a bigger piece of the state budget, which comes from the taxpayers. Is that right?
Yeah, that's correct. That's where this all gets messy. And as many legislators who were pushing back against this, including us, is at some point in time, let's say the union is put in place and they negotiate a higher rate for the child care subsidy program, and on paper the child care subsidy program rates are going to go up. Ultimately, it is still the legislators who have to vote the budget through for the taxpayers to be able to pay for it.
As you pointed out, this is not actually the rate. This is just the amount of the subsidy, because you charge your own rates, which are higher than the subsidy.
In my case, my rates are slightly higher than the subsidy. We as providers can set our rates virtually however we want, as long as our business needs can be met and goals be met. And if my rates are higher than the child care subsidy program, I charge that difference. Some providers choose not to because of their care for families, and they will just write that off or forgive that amount. But it is written in our directions of doing business and the guidelines that it is intended that this be a subsidy, not a full payment. That is again where the union has twisted this. They present it as if it's a full payment and not a subsidy.
Well, I appreciate your time. Thank you very much. I hope we'll be able to discuss this further in another video call, interview, Google Hangout on there live, after the case is heard and decided, and we'll keep up the drumbeat. If there's ever anything that we can do for you here at the Competitive Enterprise Institute, and workplacechoice.org is our website specifically for this. Frankly, if you have a smartphone, people can download our app, which is WPC Workplace Choice. WPC will provide you with the votes of your federal legislators. It will also provide you with news about union and labor and employment issues. And I hope that you will be able to follow us more easily if you do download the app.
Thank you. I've appreciated that when we've sent off information that it has reached a bigger audience through Workplace Choice, and appreciate the connection. Thank you very much.